Hi, you ready? Yes, ma'am.
I picked up Mr. Mook's case today. I'm not sure how to pronounce that,
Yeah,
but
that's right.
yeah, I think he left already. But I was wondering if we could rehear PC.
Okay.
Oh, he did? Oh, okay. I'm sorry.
But I hope, because I had asked him to reach out to the complaining witness just to make sure that she's okay.
Okay.
Because if she,
One issue there. So because it was resisting, it's not in our system. Both contact information is not in our system. Now, when the office report goes through, it should be. Problem is we don't have that office report yet. I'm going to keep checking it. I can try to run through RMS.
I mean, until I know, yeah, that's Mr. Mukes right there. So until I know, I'm going to order no contact because I don't know, because she was scared of him there,
Uh-huh.
so.
I understand. I was wondering if I could, I'm just approaching on PC for it.
Yeah,
But
Oh,
to rehear PC, yeah.
okay. Sure. Do you mind reading it again? Please.
Officers were dispatched to a disturbance call on April the 19th of 2025. Officers observed the defendant to be outside of the residence with what appeared to be an injured hand. Defendant stated he had injured his hand while punching a wall when he was in an argument with his wife. Defendant stated he was drinking, quote, Crown, and requested medical attention to the scene. Officers attempted to make contact with the female at the residence.
Whoa, let's pause for a second. Did you catch that? The alleged victim was so afraid she wouldn't even open the door. That alone speaks volumes about the emotional stakes in this case. But here's where it gets tricky. What exactly defines a public place under the law? Because that's the line the defense is walking. Stick around, this legal chess match is just heating up.
Who refused to open the door. She only stated that the defendant should not be at the residence and that she was in fear of the defendant. Defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. Officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, officers attempted to place the defendant in custody for public intoxication.
Here's my problem. I didn't have a problem until that point.
Right, I understand that, Your Honor, but if the police are arresting him for public intoxication, the front door is not a public place under the statute or under case law or under the
It's outside.
definition. It doesn't
That's
matter.
right.
It doesn't matter. It doesn't fall within the definition of a public place. Public places are where multiple people go through. They're common areas. It's not a public place.
He's not in his house.
It is his residence. It's
No,
his
he's
residence.
outside.
He's outside, and I would argue.
He's
Your Honor,
outside. He's not inside the house. He's
He's
outside.
right at the front door, and so.
I mean,
Your Honor, I would argue, a mailman go up to the front door, delivery packer goes to the front door.
I don't think under the statute it qualifies. I mean, I have.
show me a case that
Sure,
says
I have the definition.
door is,
Right, I have the definition of a public place under the
I know what
Texas
the
Penal
definition of
Code.
a public place
And it's
is.
like apartments, hospitals, libraries, schools, office buildings, sidewalks, like driveways, the public road, not the front door. I mean, even the police, like, there is a reasonable expectation of privacy of going into the front door of the house. Like, it's not really considered a public place under the statute.
Show me case law, because I don't know. I mean,
I'll try, I can find.
I know I know the definition. I've seen the
Right,
definition,
yeah.
right? But show me something that says that being, near the front door is private property, so it's not.
I mean,
Right.
at the front door. I mean, that is like, I mean, people have a reasonable expectation of privacy in their home, like,
In their home,
right.
yes.
And at the, like, even at the very, like, front of the door. I mean,
We don't know exactly where he is.
but that's what the DIM says.
Okay,
Your Honor, what I would say, he's clearly not in the house, he's at the front door, he's threatening to kick the door down after they had just gone out on a domestic related call. Which said he appeared to be intoxicated, he defended himself, told officers that he was drinking Crown. They decided that based on the facts, he was a danger to himself, and they decided to place him in custody for public intoxication.
Mr. Mukes, coming up.
I'll turn the live stream off.
Martinez, Georgina?
Yes, sir.
Yes, sure. Yeah, no, to have, I mean, Brenda wants to, I don't know, we can't. She's gonna have comments. She's not calling. She can find out.
Right, I said, the messages get sent out, so get a quote about how you get here each day.
You know what I mean? So you let her know that if mom doesn't have to be contact with her, doesn't let her know to come in and get work, you can make them bond it. Yeah, I'm not, hey, let her know we're not gonna play games. I don't care.
Mr. Marlon Simmons, Your Honor. This was a DWI PTI that went south.
18.
Why for a plea?
We tested positive for THC, and alcohol, and then just picked up a charge out of Waller County for operation of a salvage vehicle on a public walkway.
Okay, so this case is 517 days old. Do you have an offer on the case?
Yes, Your Honor. This was a 12-month probation since it's been kicked out of PTI.
Okay, so you must either accept the plea bargain from the state or I'm gonna set your case for trial today. So they've offered you a 12-month probation. You talk about it with Mr. D to see if that's something that you want to do, because I don't know. Is that the only offer you have?
That's the offer I've made, yes. That's
Okay.
for now.
So,
He's already spoken with me, Judge.
so you let me know what you want to do.
The plea is ready for right up there.
Yes,
Yes, sir.
Oh, I didn't realize.
Yes, sir.
Okay,
and that's straightforward, Your Honor.
I'm going to tell you now that we've repeatedly asked you, I'm sorry, we've repeatedly ordered you not to use. So you either don't care about the bond conditions or you got a problem. And I'm going to tell you now, we put someone in residential treatment kicking and screaming that they didn't want to go yesterday. So if you continue to test, I can modify your conditions to put you into an inpatient treatment program at a minimum of maybe 3, 6, 9 months, maybe a year and a half, depending on how well you respond to treatment. Do you understand? So, and I'm telling you now, I will test you like crazy. The first instance you use, it's not going to go well. I will issue a warrant for your arrest. We will have a hearing, and if they prove it to me, because I'm not letting you go until the act is clean. Do you understand me, Mr. Simmons? This system will not fail you. The agreement that you have worked out is 180 days in jail to be probated for 12 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. Have you done a TRAS yet?
They recommended supportive outpatient.
Was that the way?
Mm-hmm. Okay.
Let's do a new one.
Stop it.
This moment right here? Classic Judge Fleischer, firm, direct, and crystal clear. The guardian interlock debate might seem minor, but it's a massive deal. Think of it as the judge drawing a legal line in the sand: drive without a breathalyzer. And boom, 6 months in jail. What do you think, fair consequence or too harsh?
Substance abuse treatment as required by the TRAS. No breath test refusal, meaning that if you're pulled over, an officer asks you to take a breath test, you must do it while you're on this probation. No drugs, alcohol, and a guardian interlock.
Judge, with respect to the guardian interlock, client has informed me that he does not have a vehicle at this particular time. So I will respect request that the board allow him to use the portable device in lieu of the guardian.
I'm okay with that, but I'm telling you now, Mr. Simmons, that you will be signing an affidavit promising you're not going to drive. I don't care what your excuse is. If Holy Mother Mary comes from and asks you for a ride from church, you drive. You can be facing an additional 6 months in jail on a contempt and a $500 fine every time you drive. Do you understand?
Sure.
Do not drive. Is it because he doesn't have a license?
He does not have a vehicle to inform me, Judge.
Do you have a driver's license?
Yes, sir.
Okay. We are sending notice to DPS so that every officer in the state knows if you are in a car driving, you are to have a guardian interlock, a breath test device. If you don't, you're caught driving a car. They're going to put you in jail. Don't be sneaky. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, to confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this. The other thing, Mr. Simmons, is this now will reflect as a conviction on your record. You ever get pulled over in the future, be it 20 years from here, 30 years, you even have the faintest smell of alcohol or dope, they're going to see this DWI. It's probably not going to go well for you. Do you understand? How do you plead to the offense of driving while intoxicated? Guilty, and I'm guilty. I'm going to find you guilty. I'm going to send you to this agreement. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. Dean. Picked up a new case?
It was a failure to ID, and I'll pull it up now.
She actually had this one.
She has some experience.
I do apologize. I was trying to pull a arm as judge, which is now.
Take your time, Blaze. There's never a problem. Can you read to me what happened on the failure to ID?
Absolutely. April 22nd, 2025, officer dispatch in reference to a in reference to an earlier motor vehicle, complainant stated that at 4:30 a.m. she heard a car alarm go off and looked out the window and saw two individuals leaving.
Oh my God, you're telling me this is a BMV?
No, it's not being beer.
That's the co-defendant,
It's the
Judge.
defendant.
She's with. This is a party.
Not charged though, Your Honor, say that, but, complainant person, suspects, and defendant Silva stated that she was, quote, going to beat her ass if she kept following me. Complainant was able to flag down an officer. And the defendants, the other complaining witness, the owner of the vehicle, said that the officers, there was a red paint on the front seat of the complainant's motor vehicle. Complainant observed that a bike that defendant Silva was riding on had red paint on the seat, and the back of defendant Silva's pants was also red paint. During the investigation, I observed defendant Silva with red paint on the back of her pants. During the investigation, defendant Silva admitted to going to the vehicle to find things changed. Once the defendants were detained, officers asked what the defendant's name and date of birth was. She first stated that her name was Sierra Johnson, date of birth 4/18/2002. Officers asked for a clarification on the spelling. Officers then asked if she ever had a Texas driver's license or ID. She stated she did not. Officers ran the given name, but nothing came back. Officers then called for Mogan Aphis. While officers were waiting, he asked the defendant what her name was, and she said that her name was spelled Sierra, Ceirra, with a C instead of an S, and that Johnson was her mom's last name, and that her real name was Torrance. Officers ran the new name and Texas driver's license, came back to defendant Torrance with multiple City of Houston precinct 2 warrants.
So the co-defendant got charged.
They're going to be charged, Your Honor. I'll pull it up now.
Why not Ms. Torrance?
I'm not going to read in here, Judge. I don't want to speculate, but I think all of the evidence can point to the co-defendant. And in fact, co-defendant admitting to going into the vehicle.
There was red paint in the car.
Right.
She has red paint on her.
That was.
No, that was co-defendant. I don't.
Was she acting as a lookout?
I don't know why intake did not take a B&B on this. I don't want to speculate. All I can see is that obviously there was a decision made at intake that they didn't have enough for B&B, but they had.
Anna, as much as I love you and as much as I appreciate your tenacity, no, there's something going on that's a lot deeper with this, and I'd like to find out. And what I'd like to do is have her T-RAS, essentially, but it's, I don't know what we need to do to get through to you, Miss Torrance, but apparently of all the stuff that we've dealt with now, in your case is what? 241 days, and yet we
Judge, if I may, this is a DWI. We got the alcohol report back and they sent it off to get tested for tox. We still do not have that toxicology report. And when we were.
I get it.
Okay.
I'm not saying.
It's just, she's not the one dragging it out. It's been waiting on the test.
You are on
Yeah.
law. You've now picked up a new case. I've repeatedly asked you to behave yourself while on bond. That you are not charged with 2 cases and you merely have the one. I'm now revoking your bond number, DWI, and I'm taking you in. And what I'd like to do is have her T-RAS
Okay.
immediately to
Okay.
see how we go forward, because this is, in my opinion, throwing her to the wolves, because something is going on and I'm going to try to nip it before it becomes felonious.
Judge, we do have an alternative offer on there that would include the T-RAS.
I want to do it first
Absolutely.
so we see how to go forward, because I don't want, I just,
And while we're here, actually, let me talk to the state about this before I'm gonna give them a heads up.
And I'll send it in.
right. Mr. Bada, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement that they're offering you 3 days in jail with credit for the 1 day that you have done. You are giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. It will be there forever. From now on, you are facing a minimum of 30 days in jail. You pick up any more DWIs. And I'm going to tell you, because it's going on your record, you get pulled over and you have anything funky to smell, whether it's weed, whether it's alcohol, what do you think is going to happen? Right. If you want to get lit, if you want to smoke until your heart's content, don't get into a car. I know that he has done above and beyond the call of duty in representing you without probably taking it. For all the money that you have saved, $50 will get you a ride to wherever you want to go in this life. Do you understand? I don't know if I'm going to waive the supervisory fee with him. I don't know if he's truly indigent or not by OG.
I would respectfully,
I know that you are, but I don't know. You know, I know that you've been throwing everyone for a loop the entire time, and so I want you to fill out an application from where you saw. I know that you are truly indigent. You're going to swear to this document. This is a public, not a public, but this is a governmental document that you're going to swear to. I want to know about your financial situation. I want to know everything about you. How much money you have at the bank, how much money you have coming in, how many cars you have, and then we'll take a look to see whether you're truly indigent. You understand? I'm going to suspend your license for 180 days. Do not drive until you get a license. So we will have you fill out an affidavit and I'll see whether you are indigent and then we'll take a look. But really, this dude is really gone above and beyond the call to represent you for all the issues that you've had. So thank you so much for doing what you're doing. How do you plead to the offense, guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement. And you're going, do you mind getting an application so we can work to see? Okay.
And Your Honor, do you need me to approach with?
No, I'm just gonna, I'll look at the document. If he does, then I'm gonna waive it. If you do not qualify, you will be required to pay the supervisory fees. In this case, that is $3,000 plus court costs. Actions have consequences. You had the opportunity. When you pick up a DWI, you're going to pay for it one way or the other. You know, now this, with the conviction, it's gonna follow you forever. All I hope is that 20 years, 30 years from now, this was enough of a hassle in your life that you, man, I had 3 beers. I better not get into a car. Time heals all wounds, but the law never forgets. Good luck to you. And
Thank you,
thanks,
Your Honor.
Sabaji. Okay, you ready? Come on up, sir. How are you? So, Mr. Randall, you're charged with failure to identify oneself as a fugitive from justice. That is a Class A misdemeanor. That was from 2022. And I guess you didn't show up for the arraignment, I'm assuming, so we revoked the bond. We issued the warrant. 3 years later, now you've picked up an assault bodily injury. On that one, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you.
Yikes. A random "have a good day" turned into a brutal beatdown with eye gouging and bite marks? This sounds less like an argument and more like a horror film. It's a reminder that courtroom transcripts can reveal just how fast things can escalate. On the street. Question for you all: should psychological evaluations be mandatory in cases this extreme?
Cannot afford one will be pointed to you. I don't know what happened in the assault, so we're going to find out real quick. Okay, what happened?
Judge, before we get started, there is some use of profanity that's pertinent. How do you prefer to?
Dude, we don't have virginal ears. You can do whatever you want. Say it.
On April 22nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched to an assault in progress call and made contact with the complaining witness. The law enforcement officer observed the complaining witness to have blood on their face and fresh cuts on his face and near his eye. The complaining witness stated he walked on a bridge and passed the defendant and told him to have a good day. The defendant then stated, "What the fuck did you just say to me? You got a problem." The complaining witness told the defendant that he didn't have a problem and did not want any trouble. The defendant then got into a fighting stance and struck the complaining witness in the face multiple times, took him to the ground, continued striking him, and stuck his finger in the complaining witness's eye. The complaining witness stated he was in fear for his life. A witness corroborated the complaining witness's story.
Any damage to the eye?
Law enforcement officers took pictures of what he recognized to be a bite mark on the complaining witness. I will look for further damage evidence. The officer observed the complainant's eye being red and the bottom part of his eye having a fresh cut and abrasions on both sides of his face and above his forehead.
Okay, Mr. Randall, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. I don't know if you're going to bond out, but if you do, I'm going to put a monitor on your ankle because you're a flight risk.
Not gonna go anywhere. I mean, the assault
So
charge.
don't talk about it, really. You have the right to remain silent, exercise the right. That's why you have a lawyer, because whatever you say now, they're going to sit there, type it to try to use it against you. Just best not. So the problem is that I can't give you a PR bond. We gave you a PR bond last time and you took off. Now, 3 years later, you picked up a new case. And the only reason we have you back is because of this. So I can't just give you another PR bond, you know?
And Your Honor, Mr. Randall would like me to communicate to the court that he was under the impression that his prior offense was dismissed and it was a misunderstanding, but that he has every intention to satisfy his obligations.
I get it. I understand. Where do you live?
I believe he's kind of in transient at the moment, Your Honor.
And that's a problem because I don't want to just give you another PR bond and you're going to end up on the street. You know,
It's hard to get lodgings here.
allegedly here, they're just wishing you to have a good day. Have a good day. And now, you know,
We have provided him with resources in order to try to find lodging and the like. So I think you said you were going to take advantage of that information that I gave you.
yeah, I'm sorry, I can't. You know, you scare me. You know, you take off. And the only reason we have you back now is because
Sir,
of have a nice day.
no, I didn't take off. I've been right here in the city of Houston. It wasn't a flight risk or me ignoring the conditions of the PR bond. I showed up to the court. Like I said, the discrepancy said just with the criminal justice system up to this point is paramount to pretty much everything.
Who do you have in your life? Where's mom?
Lord.
Where's dad? Where's brother, sister? Who do you have
I'm
in your
here.
life?
I'm on my own. I actually came here to Texas to take care of VA and Social Security disability to acquire a resource to just take care of that simple business and go back to Germany. That was it.
Germany, he said, Your Honor.
But I'm not a recluse or a loose cannon. How they trying to paint? It's wrong. That guy.
Don't talk about the past.
So if you had somewhere to go, like family members that are willing to take you in, I would consider, but just to go back on the street. My fear is that we let you out and then the same thing happens again, where you just go out and then we just don't see you again, you know? So I don't know if you can somehow try to reach through some family or anyone that he may have, talk with them, and then I guess we'll go from there. Okay? All right. Good luck,
We're
sir.
asking for a short recess. We spoke with the
Absolutely.
state.
For sure.
We'll try to resolve this.
Maybe a couple days or however long you want. And
So,
yeah. All right. Good luck, sir.
thank you. Comes out right.
Judge, can I call up the arraignment?
Hey, Nathan, can I do an arraignment real quick?
Well, I'm just gonna take a minute of your time.
Okay, come on.
Hi,
Great to
Judge.
see you, man. What's new? Happy Fridays?
Yes, Judge.
Morning, gentlemen.
So these are two U of H pre-law students.
Great.
All right, so Peter and Elijah, their class is getting a tour of the building, and when I was picking them downstairs, they had mentioned that they had seen you and they wanted to meet you.
We saw you on so many times on TikTok, and it's a great honor.
Yeah, I don't know who I don't put it on there, so I have no idea, but
You've gone viral, like I've seen so many times, and I'm amused, like by the way you handle
By the
stuff.
way, they have no idea who I am.
No, but we know who you are. So we were just wondering if we could just get a picture of you.
Let's skip that part.
I'm okay with it. Yeah, I'm okay.
So I
with
know
it.
there's like
Just let
I don't know
me
photography about, but
just do a couple things here and there, and then if you just give me a couple minutes, I'm happy to take a
All right,
picture.
Judge, I've got to actually run to another court, so if you don't mind, can I leave them in your jury box?
No, not in the jury box.
Okay.
Where?
The witness stand.
Oh, yeah, if you can hang out in the witness stand here.
Now can we call up the arraignment?
Sure.
All right. Page 13, Ms. Morris, come on up, please.
Yes or no?
Judge, I thought she was one of the ones that had him with somebody. That was one.
Okay, not a problem. Coming up, Ms. Morris. Good morning, ma'am. Ma'am, you are charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance and made contact with the reportee who stated the defendant had left the scene. While speaking to the reportee, the defendant drove up to the scene and the law enforcement officer observed the defendant exit out of the driver's side of the vehicle and was the only person in the vehicle. The law enforcement officer observed the defendant to have red, glossy eyes and slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN. A 3 out of 4 was recorded on the one-legged stand. It states here that the other test was refused. The law enforcement officer found an open alcoholic beverage, mostly empty, and cold to the touch, and the center cup holder and several other unopened alcoholic beverages cold to the touch. The defendant refused to provide a specimen. Blood warrant was obtained and executed.
Did you say that there was an accident initially that brought them to the attention or what?
Judge, it just says that the law enforcement officers were dispatched to a disturbance and the defendant drove back to the scene that she had left from.
My fiance.
Stop. Don't. You have the right to remain silent. Exercise that right.
There's no accident, Your Honor. It was just, they were called out to a disturbance. I believe it was a disturbance with. There's a disturbance under the weapon call, Your Honor. They drove up to the location, and made contact with a complainant witness who stated, that the defendant had left the location, and then while they were speaking to the complainant witness.
That's when she comes back.
That's when the defendant came back.
Okay. All right, Ms. Morris, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive at all. I'm now going to have you sign an affidavit with me today promising you're not going to drive. I don't care what is going on in your life. You will be signing an affidavit with me today promising you're not going to drive. Do you understand? Because this is a second offense, you will be required to obtain a portable interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. I will also randomly test you for drugs. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds. Do you understand, ma'am? You're sending notice to DPS now that I'm placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have a guardian interlock. If you're caught driving a vehicle, it doesn't have an interlock on it, an officer in this state will know that you're required and they will arrest you and put you in jail. And you're in violation of these bond conditions. Do you understand? You have the ability to hire a lawyer, man. We're going to give you time to hire a lawyer. So what I'm going to do is I'll have you go to Victoria, sign a reset. I'm going to first have you come up here, swear to us that you're not going to drive. You will then get with pretrial services for your bond conditions. And then after that, you'll be free to go. Do not use. Do you understand? Alcohol or illegal drugs. It's not going to go well. I didn't say you couldn't work. I just said you. I'm ordering you not to drive.
They put an interlock in there already.
Okay. Right.